At common law, for a contract to be formed, the acceptance must exactly match the offer's terms. If the purported acceptance alters or adds to the offer in any way, it's treated as a rejection and counteroffer. This is known as the mirror image rule. Due to its rigid application, the mirror image rule can hinder the efficient formation of contracts, particularly in modern commercial transactions. To address this issue, Article 2 rejects the mirror image rule in favor of a more flexible approach. Imagine an electronics manufacturer was interested in buying computer components from a supplier. The manufacturer emailed the supplier, expressing interest in purchasing 500 components for $200 each. Attached to the manufacturer's email was its standard terms and conditions form, which included a provision stating that any disputes would be resolved through arbitration. The supplier responded that it could provide the components at the specified price. However, in the email, the supplier included its own terms and conditions, including a clause limiting the supplier's liability and a clause stating that any disputes arising from the transaction would be resolved in Delaware state courts. The parties exchanged no further emails but began performing. Was a contract formed? And if so, what are its terms? Under Article 2, an acceptance may be valid even if it contains terms additional to or different from the original offer. The general rule is that if the offeree sends a definite, seasonable expression of acceptance or a written confirmation within a reasonable time, a contract is formed. Here, the manufacturer made an offer, and the supplier responded with an acceptance in a reasonable time. Thus, a contract was formed, despite the fact that the supplier's acceptance contained additional and different terms. In a moment, we'll discuss how we determine which terms are a part of the party's final contract. But first, let's consider another scenario.